Hello, good afternoon, everyone. Uh, so today's topic of the webinar, I'm going to cover and talk about demystifying FDI, ODI, and LRS compliances for global entrepreneurs. So before we start, good afternoon, everyone. And this topic we are doing this webinar after a long time after the COVID lockdowns and everything. I'm going to talk about some important issues that entrepreneurs face when they raise funds from foreign entities or foreign investors. Also, when an Indian entity or an Indian investor wishes to invest in a foreign entity outside India, so which comes under the ODI regulations, and when the company receives an Indian company receives funds from Indian foreign residents, FDI regulations. So, and I'm leading the track of global expansion investment plans here at Mantra Global. And so I'll start sharing the screen, and we'll talk about the important areas that an entrepreneur needs to look into. I guess I'm audible. If someone can please write something if I'm audible or not. So yeah, let me start sharing the screen. So friends, this webinar, what I'm going to do is I'm not going to talk about the nitty-gritties, and I'm not going to focus on the jargons of the entire compliance structure, but I'm going to talk about how it is important, and yeah, a little bit focus on what you should be doing, what an entrepreneur should be doing while you raise funds from abroad, or you actually repatriate the funds, or you transfer funds to any foreign nations or a foreign entity for investment in any sort of a security. But before we begin, I thought of giving some glimpse into the Indian startup ecosystem, why we have chosen this particular topic of FDI, ODI, and LRS. So today, as we are doing this webinar, I mean, as we stand today, we see that the Indian ecosystem, startup ecosystem, is the third largest startup ecosystem in the world, just behind US and China. We have, in fact, surpassed UK as well. As we speak today, we have 102 unicorns in India. I mean, a startup which has a valuation of $1 billion. The most the important sectors which have been able to raise the funds were from e-commerce, fintech, edtech, consumer services, and we have seen that in the last year, 2021. And even the run rate continued in the first quarter of 2022, calendar year 2022 as well. At very recent news, couple of days back, we heard that Sequoia India and Southeast Asia has recently raised $2.85 billion, and that is highest ever in one tranche by any VC. And these funds that Sequoia has raised would be used to fund Indian startups. Coming to what are the things that needs to be taken care of while undertaking a foreign remittance. These are FEMA and RBI laws, income tax, transfer pricing, specifically from the point of anti-avoidance rule, the DTA, place of effective management, general anti-avoidance rule, which is called the GAR, and the rules and regulations that are prevalent on that particular country. I mean, if Indian entity is doing a transaction with US, we'll have to consider both the laws, both the perspectives, both the tax law perspectives, both from US and India. But although we have too many things, but today's webinar we are going to cover mostly on the FEMA and the RBI laws and what needs to be taken care of. So to highlight, when we talk about FDI, which is receiving funds in an Indian entity from a foreign investor. So when you talk about FDI comes under two different routes. One is approval route and the other is automatic route. When we talk about automatic route, it doesn't mean that you do not have to comply with any regulations of the government of India, but rather that comes under the automatic route, and you get the money and then you report the transaction to the RBI within a stipulated time frame and with all the documents that has been put forth by the regulatory bodies. Now, what are the sectors which usually under the 100% FDI route? So you can see agriculture, animal husbandry, auto components, electronic systems in the field of IT, ITES, medical devices, tourism and hospitality, healthcare, pharmaceuticals. But this healthcare and pharmaceuticals and biotechnology, what you can see on the screen, the 100% FDI is allowed under automatic route in case of greenfield investment. Now, talking about what is a greenfield investment? A greenfield investment is a foreign direct investment where a company invests in a new facility to start its operations. So an entity in India which is starting its operations for the first time, and you are raising funds for that from a foreign entity or a foreign individual, that would fall under the purview of greenfield investments. And we call it greenfield FDI. Any subsequent rounds of funds that the company would raise from a foreign entity or individual, that would fall under the brownfield. So anything which comes under the greenfield, it is under the, we will call it that it is under the, allowed under the 100% FDI and automatic route. What is FDI under approval route? Approval route is a little bit different than the automatic route. In approval route, the entity in India is allowed to raise the funds from a foreign investor, but subject to prior approval from the government. Now, there are several sectors which would require prior approval from the government, but I would talk a little bit about how the approval is required to be sought. So there is a standard operating procedure highlighting how a startup should actually approach the government and ask for the approval before receiving the FDI. So the first thing is you need to apply in the Foreign Investment Facilitation Portal. So this is a portal under which you will actually apply for the approval. Now, earlier it was Foreign Investment Promotion Board, FIFB. Now, once the application is submitted, you will also have to submit several other documents as well while we make the application. So what are the documents? There are several documents. I mean, starting from a board resolution. So board resolution is the company will actually pass a board resolution that they wish to get the FDI from this entity. What is the user? What are the users? And this comes under the approval route, and hence the approval is being sought. So a board resolution, the certificate of incorporation for that entity. And then there are several other chartered documents like the MOA, Memorandum of Association, the Articles of Association, all these things. past the audited financial statements and income tax return copies, and if there are any prior approvals from the RBI that has been received, those documents, all of them have to be submitted to the FIFP while making an application for under the approval route. What needs to be done is there are certain events wherein, so what happens, so once you submitted the application to the FIFP will then take it up internally, and they will also approach Ministry of External Affairs or Ministry of Home Affairs if the case is required in such events, and they might ask for additional documents as well while the approval is sought. So once they scrutinize all the documents and they find it valid and proper, and if the grounds of raising the funds are on merit, then they would give the approval, and only after the approval is received you can actually call for the money from the investors. The money comes in, and then you do the next set of compliances wherein you issue securities or shares or debentures, whatever it is, you issue them, and you then file the necessary forms, which I'll talk in the upcoming slides later. But when you file those forms and you do those compliances, you will also have to submit the approval copy received from the RBI. Coming to some recent changes which have been announced by the RBI under FEMA laws, and there has been some changes in the FEMA law. One of the biggest change is the acquisition of shares after renunciation of rights. So what we used to see under the provisions of the Companies Act 2013, we see that a company can issue securities to an investor under two different routes. One is under private placement, and the other is right issue. Under private placement, when you do it under private placement, you actually identify the investors and then issue the securities directly to those investors upon receiving the money. Under right issue, what happens is the company actually issues the shares to the existing shareholders of the company, and the existing shareholders are given the right to either renounce or decline the shares. So if they renounce the shares, they renounce it in the favor of someone else, and that person, if they wish to subscribe to the shares, they can subscribe to the shares. Under declination, the existing shareholder might decline to subscribe to the shares, and in that event the board may have the right to actually allocate the shares to a third party, to a non-existing investor. So what we earlier saw was that right issue, if a company had issued shares under the right issue, then upon filing of the compliances to the RBI, we frequently saw that the RBI doesn't approve such transactions. They would say that this transaction is not a valid transaction. We had to do several set of communications and submissions to actually explain them that this is under the law. However, the Ministry of Finance came out with an amendment notification on 27th April 2020, and they have said that non-residents can now subscribe to renounce shares. So a resident Indian, a resident shareholder, or an existing shareholders can actually renounce their shares in the favor of a non-resident investor, and he can then put on the money and subscribe to the securities of the company. Talking about the compliance that I was referring to some time back, what are the compliance actually when the money is actually received in the form of FDI? there are two separate set of compliance. One is filing of form FCGPR. So I'm keeping apart the compliances which are required under the provisions of the Companies Act, because this webinar mostly focuses on FDI, ODI, LRS. So I'll talk mostly from the perspective of RBI and FEMA regulations. So keeping aside the Companies Act provisions and the compliances required under those provisions, we will also have to comply with the FEMA and RBI compliance and regulations. So one compliance is FCGPR, which is a form. The other form is FCTRS. So what are the difference between these two forms? So FCGPR is a form which is actually filed when the company is issuing the shares. So it's in case of a primary issuance of shares. So a company is issuing shares from its pool, and wherein the paid up capital of the company is increasing. So the company will have to file FCGPR. That too, again, I would like to reiterate on this position. The FCGPR will only be filed for those investors who are non-residents. So an investor who is not a resident of India and he invests in an Indian entity, the company will have to file FCGPR. What is FCTRS? FCTRS is filed with RBI for transfer of shares. So an Indian resident, when he transfers the shares to a foreign resident, in that event, the person, the individual, the company has to comply with the comply by filing form FCTRS. Now, talking about the timeline, so it's 30 days. So if the shares has been issued, then within 30 days, the company will have to file FCGPR. Along with the filing of FCGPR, there are several other documents that needs to be submitted, like a valuation report, a CS certificate, and the most important part of the documents while submission of FCGPR includes the FIRC and KYC. FIRC is the Foreign Inward Remittance Certificate, and the KYC, which is a Know Your Customer. So these documents are actually being provided by the AD Bank of the company. So the banker that with which the company is dealing with, they are responsible for providing you the documents. Similarly, in case of FCTRS, the only difference is that you would not need a CS certificate currently, but you would definitely need a valuation report. But the FIRC and KYC are again the mandatory documents. And apart from that, there would be a share transfer agreement or a give deed, which would be executed between the two different parties. And FCTRS, as I said, this is not a primary issuance of shares, rather this is a secondary transfer wherein one individual or one company which is a resident in India is actually transferring his or her holding to a foreign resident. So these are the difference between FCGPR and FCTRS. Talking about now coming to so this part, what I have discussed about, it falls under the purview of the foreign direct investment, wherein the Indian entity is actually receiving money from foreign investors. Now coming to the overseas direct investment, which is ODI. ODI is just the opposite of it, wherein an Indian resident or an Indian party, which is an Indian entity, is actually transferring the funds to abroad or subscribing shares in a foreign entity which is located outside India. So that falls under the purview of overseas direct investment. Now, again, under the ODI regulations also, we have two different routes. One is the automatic route and the other is approval route. Now, what happens in case of ODI? But before I move on to ODI, I'll throw a little bit of light on the FDI structure once again, because this is very important. In FDI, what happens is we actually receive the money and then report the transaction to the RBI. This happens in case of automatic route. So we receive the money, we report it to the RBI. In ODI, it is little different, wherein we actually ask from the RBI before remitting the money to the foreign entity and subscribing to the shares. So once we file the ODI form with the AD bank, so how it happens, we directly don't file it to the RBI. We have to go channelize the entire documentation, set of documentations to the AD bank, which is the authorized dealer bank of the Indian entity. So we prepare the entire set of documents for ODI, prepare the form, and then submit it to the Indian AD bank. The Indian AD bank will scrutinize the same, and then they will forward it to the RBI later, upon which they will issue a UIN, which is called the Unique Identification Number. Once the UIN is issued, the Indian entity is authorized to now transfer the funds to the foreign entity for subscription of securities. Now ODI here looks a little bit different. Now this is not something that I'm talking about which comes under the approval route. This is automatic route definitely. But what happens is you have to first comply with the regulations, and upon receiving the UIN, you can actually transfer the funds. Some of the sectors where ODI is restricted includes real estate, banking businesses, financial services. These are restricted. However, you can fulfill some of the regulations of the RBI, and there are certain restrictions, and there are certain rules and regulations which you will have to comply if you wish to do the ODI transaction in these sectors. Talking about the limit, the ODI limit for the companies. So RBI has set a limit of ODI for the Indian companies, which is 400% of the net worth of the Indian entity as per the latest audited balance sheet. And this falls under the automatic rule. So if it is within the 400% of net worth of the Indian entity, as per the last audited or the latest audited balance sheet, then it will fall under the automatic rule. Anything which surpasses, which goes beyond 400% of the net worth of the latest audited balance sheet, in that event, the Indian entity has to take a prior approval from the RBI. A very, very important point that I am going to highlight here is there is an RBI restriction on round tripping laws. So what is round tripping actually? It says that, I'll give a very simple example, and probably a lot of startups might be facing this hassle or might have faced this hassle earlier. So round tripping laws actually prohibit an Indian entity to have a step down subsidiary or a JV abroad, which will then have a subsidiary or JV back anywhere in the world. So that particular thing is not allowed by the RBI. So the question is, can an Indian party set up a step down subsidiary or joint venture in India through its foreign entity? So through its foreign entity, that foreign entity might be a wholly owned subsidiary or a JV. Can it set up directly or indirectly through a step down subsidiary of the foreign entity? Can it set up an entity? The provisions are very clear. It says that no. Dealing with transfer and issue of any foreign security to residents do not permit an Indian party. Indian party is being referred to as an Indian company to set up an Indian subsidiary through its foreign wholly owned subsidiary or a JV. Not do provisions permit an Indian party to acquire a wholly owned subsidiary or invest in JV that already has direct or indirect investment in India. So that particular provision restricts an entity to do round tripping. So there are several ways how we can actually structure this entire mechanism so that you can actually have a foreign entity in India. You can actually have a wholly owned parent in abroad and a subsidiary in India, or a parent in India having a subsidiary abroad, and then the company having a subsidiary somewhere else. So you need to do that sort of a structuring before, and the entire goal should be kept in mind. What is the entire goal of coming into that structure wherein I wish to do this? And then we can structure it in that manner. The next part is liberalized remittance scheme. So we have covered FDI, we have covered ODI. The third is the liberalized remittance scheme, which is called the LRS. So LRS is something which is mainly concerned about the resident individuals in India. So the LRS scheme actually allows a resident individual to remit a certain amount of money during a financial year to another country. Now that remittance can be for any purpose. Either it can be for investment or for expenses. Now what is the threshold? The threshold is the resident individuals can remit only up to $250,000 per financial year under the LRS route. And this money can be used for any purpose, like subscription of shares, debt instruments, to purchase any kind of immovable properties, foreign currency, or gifts, medical treatment, any sort of donation to a close relative, anything. So, but this should be within the threshold limit of 250,000 USD. Now, as we speak about, and as I have highlighted about FDI, ODI, and the LRS, what is important is that we need to first understand for each and every compliance when the compliance mechanism actually triggers, and what are the important areas that needs to be first resolved before we move on to the next set of compliance structure. So if I talk about FDI regulations, wherein I highlighted the importance of filing of FCGPR and FCTRS, it is very important that when the transaction happens between the Indian entity and the foreign party, you actually have a prior conversation with your bank, with the Indian AD bank, that this is the transaction you are looking to get into, wherein certain sort of money is going to come into the Indian bank account. And hence, once the money comes in, the bank will actually have to provide you the FICCI and KYC within a very limited period of time. Why limited period of time? Because you have limited period of time to actually report this transaction. Otherwise, the RBI will end up levying a hefty amount of penalty on the company. So, creating a communication channel right from the beginning and understanding like when the entire funds are going to flow, you actually start communicating with your banker and set the expectations that this is something which is required from the bank. So when you actually start this, the bank should be actually aware about what is FICCI, what is KYC, what is the weightage that these documents have while we are complying with this sort of regulations, and particularly when RBI is involved. So proper banking partners are very important. So you need to have a proper bank who actually understands these laws and regulations, and then they will help you to actually to navigate in this entire process of raising funds from abroad. Now coming to again, the same thing goes along with ODI as well. For ODI, we have seen several startups. I mean, n number of startups and companies, even growing companies, growing companies and mature companies also, wherein they wish to subscribe to the securities. I mean, some petty issues like a company, an individual, not even a company, an individual in India might have incorporated a company in US or Singapore, and that person needs to remit the money abroad for as a subscription money towards those shares in that company. Now, what needs is say the company has been incorporated in the month of June, 1st of June. So the shares have been actually issued to that particular person. Now, what needs to be done is Mr. X, who is a subscriber to the memorandum of an entity in US, he needs to actually transfer the money for subscription of securities in US. Now, this person, Mr. X, will have to first comply with the ODI regulations before he can actually transfer the money to US company's bank account. Now, the entire ODI regulations being a very small part of it. I mean, not from the compliance perspective, but from the documentation perspective, and from the perspective of complexity as well. So when it is a very plain, simple, vanilla transaction wherein a particular person is actually subscribing to the foreign shares upon incorporation, so in that event, we will have to submit a set of documents. So there are n number of instances wherein we have seen that the particular entrepreneur has been really struggling while complying with the ODI regulations. And the only reason has been the AD bank, because the AD bank will keep on coming up to you and asking for several set of documents which you might have already provided to the banker. But it's just because your banking partner or the particular bank is not aware of all the regulations and whatever is required for that particular transaction to happen. So he will come up to you for asking several set of documents again and again. So here the most important part, as I have earlier mentioned, for FDI, for ODI also, it's very important. You need to have a proper banking partner. The second part is you need to have a correct compliance partner. So I'll give you a very recent example. This company is a growth stage company which has already raised around pre-series A funding, and this company was actually transferring the funds to actually acquire some shares abroad in a Singapore entity. Now, while this transaction was happening, they actually transferred the money to the foreign entity for subscribing to the shares without complying with the ODI regulations. So the banker, they transferred the money, the banker sent the money to the Singapore entity, and then the entire transaction happened. And suddenly, after a couple of months, when they were raising Series A, the due diligence happened, and the legal team of the investors party, they have raised up this point wherein they said that you have already mentioned that you hold such number of assets in this entity in Singapore, and however, I don't see any. I mean, they were asked to provide the ODI regulations, ODI compliance documents that they have filed. Now, the company did not have any documents for the ODI compliance for such a transaction. Now, as a compliance partner, as an advisor, what is most important is you need to understand and you need to guide that person, and you need to handhold the entrepreneur, saying that if you're really looking to do such kind of a transaction wherein you are planning to invest in a foreign entity, wherein this falls under the purview of the overseas direct investment, you first have to comply with the ODI regulations and then transfer the money. So, I mean, a continuous communication channel should be there between the compliance partner and the client company. So that will shape up the entire future and entire corporate governance of the company, as well as to how long the company will go in raising funds and growing the company to the next level. Another important thing is, while these sort of transactions happen, either in case of FDI or in case of ODI, we'll also have to see that the company is not violating any of the tax law perspective from both the angles, from foreign tax law perspective and from Indian tax law perspective. So the company or the investor cannot afford to violate any of the tax regulations. The other thing is funding. So funding, I mean, this is a buzzword in any startup. So when you are raising a fund from a VC which is located abroad, or an HNI who is a foreign investor, and you are raising the funds from them, you need to understand that there are several set of compliances which needs to be done at the right point of time. Again, I will again talk about the documents like FICCI, KYC, the valuation reports. When the valuation reports are required, when should it be prepared? The valuation report has got a certain timeline within which the valuation report should be prepared, and within which from the date of the valuation report, within which the allotment should take place. So there is a whole set of timeline guided by the laws of this country, and you cannot violate those laws, because once you've done it, you cannot go back and prepare a valuation report and then file it, and then say that this is the valuation report that I have done and then the company has prepared. So you need to get those things right before you actually start the entire funding process. So it's not a one pointer agenda wherein the funds are just being raised by filing a couple of forms, but it starts from the very day when the entrepreneur or the company actually thinks about raising the funds from investor. The other part is what I was talking about is structuring. So you might be actually structuring your entity when you are raising funds. So maybe if you are setting up a foreign parent somewhere outside India, or maybe you are setting a subsidiary of your current parent company in India. So in both the cases, you will have to structure the entity, keeping in mind what is your ultimate motive. Why do you wish to draw out this structure for your entity? What is the actual intent? So when the intent is known, you can actually structure it in that manner. It cannot happen that I did this company or I made this company just because I have got some certain set of customers in that country, and I have just incorporated a company there and I'm doing the transactions. But eventually down the line, we will see that although we have started this company, we have formed this company, there has been several gaps in the compliance structure. And then the ultimate intent might be when you are raising funds, any investors, when they invest in your company, is to take an exit. And as a founder, as an entrepreneur, the entrepreneurs have to give them a proper exit to the investors. So what's more important is that when the entire structure is drawn, when the entire structure is put into an idea, you need to understand what is the actual motive and how do I really need to do it, so that there is a win-win situation for everyone, for the company, for the stakeholders, for the investors, and for the founders and entrepreneurs as well. So structuring of the entity, again, it requires a proper compliance partner. You need to know what sort of a structuring is required so that you stay well within the laws, and then you structure the entity complying with all the regulations. So just to wrap up, we spoke about the FDI, wherein the money flows into Indian entity, the ODI when the money flows out of India, LRS mostly specifically speaks about Indian residents when they remit the money abroad, and the compliances that are required to be made for each of the transactions that takes place, and the requirement of a proper banking partner and a compliance partner, and how this can help you. So I've tried to keep it a very short one, mostly highlighting on FDI, ODI, LRS, and what are the basic compliances and how you need to take care of those compliances. I mean, if you have any queries, you can definitely drop us a line at info@taxmantra.com. And if you have any specific questions, I'm happy to answer those questions. So I don't see any questions. Fine. Fine. So I think we can end this session, and we will come up with another session soon, talking about some more burning issues or the issues which are actually affecting the entrepreneurs and the companies in India or abroad. Vinay. So Vinay has a question where he says that can we issue a debit note or invoice to our WOS? Yeah, Vinay. So we need to understand what sort of transaction is this. But yeah, definitely. I mean, if we structure it accordingly, then that can be done. But we need to see, first see the structure from both the perspective. We will also have to see the DTA provisions and all, and how the structure has been done, initiated between the India and your wholly owned subsidiary. I assume that this wholly owned subsidiary is a so Vinay, the ODI is actually transferring the money from India to abroad. I assume here you were talking about the payment which will come from abroad to India, but that's it. This is through an ODI mechanism, and this will not fall under the direct investment because this is invoice and this is not an investment. Vinay, you can reach out to us. You can write us or you can call us as well. We can get on a call and sort this issue. But yeah, I mean, this does not fall under the purview of ODI. So, friends, we will come up with another session soon. And Vinay, you can reach out to us. We can have a call. And thank you everyone for joining with us. And connect soon on some other webinars, some other webinar when we decide on that. So thank you and stay well. Bye bye.